It stands on the east side of Toronto, set back from Gerrard Street, behind a wall of Credit Valley sandstone the color of dried blood. The facade is Romanesque Revival. Arched windows, decorative brickwork, the careful stonework of a building that was meant to announce something about the society that built it. At the center of the entrance block, a dome. Not a large dome, not a dome that dominates the skyline, but a dome that uses the same architectural language as the courthouses and legislative buildings of Victorian Ontario. The language of civic seriousness, of a society that had thought carefully about its institutions and trusted them. The Don Jail has been on this corner since 1864. It has watched Gerrard Street change in every direction. It watches it still. But this is not a story about architecture. In the autumn of 1972, a man named Arthur Morin was held inside this building on remand. He had not been convicted of anything. He had not been tried. The law that put him there still considered him innocent. He complained to guards of chest pains for 3 days. The duty register logged his complaints as manipulative behavior. On the 3rd day, Arthur Morin died of a heart attack in his cell. He had never been tried. His charge had never been proven. The law called him innocent until the end. The Don Jail processed him as something else entirely. This building held men and women like Arthur Morin for 150 years. It held them not as convicted criminals, but as people awaiting trial. People the law, in its formal statements, presumed innocent. It held them in cells built for one that it filled with 3, in temperatures documented to exceed 100 degrees Fahrenheit in the summer months, with buckets in the place of toilets and windows, sealed against ventilation, and documented evidence of what was happening inside, reaching the government's own desk in report after report after report. This was the Don Jail, Toronto's primary remand facility for 1.5 centuries, built in 1864 as a monument to progressive penology and maintained for the century and a half that followed, as a monument to something considerably harder to name. If you're drawn to the histories that civic institutions prefer to leave in the archive, you're welcome to subscribe and keep exploring with me. To understand what the Don Jail became, you must first understand the city that needed it. By the 1850s, Toronto was no longer the colonial town of muddy streets and wooden buildings that the early settlers had built on the north shore of Lake Ontario. It was a city. Not a large city by the standards of London or New York, but a city with aspirations, industrial, commercial, self-governing, and deeply invested in the project of appearing civilized. The railways had arrived, the factories were arriving, and with the factories came the labor, waves of Irish and Scottish immigrants, many of them arriving in the specific condition that mass displacement always produces: desperate, poor, without the social networks that make poverty survivable, and therefore visible to the institutions of civic order, in ways that comfortable people were not. Toronto, in the 1850s and 1860s, was simultaneously building its self-image as a city of order and propriety. The nickname Toronto the Good was beginning to circulate, and producing, through its factories and its tenements, and its absolute absence of anything resembling a social safety net, the conditions that generated the crime, the vagrancy, the public disorder, and the visible poverty that challenged that image. The solution that the City of Toronto and the Province of Canada West had been discussing since the late 1850s was a new jail. The existing facilities, the old York Jail on King Street, various lockups and police cells scattered through the city, were inadequate, overcrowded, and, in the view of the reformers whose voices shaped the debate, insufficiently modern. Progressive penology, as the era understood it, required architecture, required the right building in the right location with the right design. The right design meant the separate system, individual cells, the isolation of prisoners from each other, a building organized around the principle that the management of prisoners required the systematic control of their contact with the world and with each other. It meant something that looked serious, that looked considered, that looked like a society that had thought about the problem. The province of Canada hired the architect William Thomas to design it. Thomas was one of the most respected architects in the province. He had designed St. Michael's Cathedral, the St. Lawrence Hall, buildings that defined what Toronto looked like at its civic best. He gave them a dome, and the dome, from the street, made the promise that the building, from the inside, would spend 150 years being unable to keep. William Thomas was not a man who built things carelessly. He brought to the Don Jail design the same deliberate seriousness he brought to every commission. The belief that architecture was a moral statement, that a building communicated the values of the society that raised it, and that a jail, properly designed, could itself be an instrument of reform. He had trained in England and brought to Canada the full vocabulary of Victorian institutional architecture, the Romanesque revival arches, the careful proportion, the use of local stone to root the building in its place. He had studied the reform literature. He had read the arguments about what a modern correctional facility should achieve, not simply the containment of prisoners, but their rehabilitation, their return to productive citizenship, their transformation from a problem into a contribution. He designed the Don Jail to reflect those principles. The individual cells were larger than most contemporary facilities provided. The building had proper ventilation shafts, in theory. The entrance rotunda and its dome were designed to communicate civic authority and seriousness. There was a chapel. There were spaces intended for labor, for education, for the structured program of reform that the era believed could reach into a disordered character and reorder it. He was an architect of conviction. He believed in the building he was giving the city. He submitted his designs. The province approved them. Construction began in 1859 and was completed in 1864. The Don Jail opened in January of that year on the east bank of the Don River, south of Gerrard Street, where the land was cheap and the distance from the respectable neighborhoods of the city was sufficient. The opening was celebrated in the Toronto press as evidence of the city's progress. The Globe described the building as admirably adapted to its purpose, combining security with the requirements of modern humane treatment. The provincial inspector of prisons, on his first visit, praised the design, but the province of Canada had authorized a facility for a specific population and a specific purpose. And within a decade, the city it had built that facility for had developed in ways that the authorization had not anticipated. Within a decade, the Don Jail was holding prisoners. The design had never been built for. In numbers, the design had never been built for, under conditions that the progressive penology of the founding documents had explicitly promised to prevent. No one was held accountable for the gap between the promise and the conditions. The gap simply became the normal state of the institution, and the institution continued. There is a detail from the construction of the Don Jail that appears in Thomas's original correspondence, and that means something different once you know the history that follows. In a letter to the provincial secretary regarding the ventilation system, Thomas described the shafts he had designed as essential to the building's function, both for the health of the prisoners and for what he called the moral atmosphere of the facility. He wrote that a jail in which men breathed foul air could not produce men who breathed clean thoughts. The ventilation was not merely practical, it was philosophical. The ventilation system he designed was modified during construction to reduce cost. The modifications reduced its capacity by approximately a third. Thomas noted this in a follow-up letter. The modification was not reversed. They could not know, or some of them could, and considered the budget more pressing than the philosophy, that the modified ventilation system would, within 20 years, be insufficient for the population the jail would be holding. That the moral atmosphere Thomas had designed around would, by the 1880s, be the literal opposite of what he had envisioned. That prisoners would describe, in testimony given to inquiries that would not save them, air that was thick and close and wrong. The dome was intact. The ventilation was not. In its first years, the Don Jail held a population that included the full range of people that Toronto's criminal justice system processed. Men convicted of serious offenses and serving sentences, men awaiting trial on charges that ranged from murder to petty theft, women in a separate ward, young offenders in a population that mixed ages in ways the reform literature had explicitly warned against. But the dominant category, from the beginning and throughout the institution's operational life, was remand prisoners, people held before trial, people who had been charged but not convicted, people who could not afford the bail that would have released them into the city while they waited for the court's attention. The bail system of Victorian Ontario was not designed to be cruel. It was designed for a world in which most people charged with minor offenses could find someone, a family member, an employer, a community figure, who would guarantee their appearance in court. It assumed a social fabric dense enough to provide that guarantee. For the working poor of industrial Toronto, for the Irish laborers, and the immigrant factory workers, and the women in domestic service, and the men sleeping in boarding houses with no fixed address, that fabric did not exist, or did not exist in a form the courts recognized. So they went to the Don jail, not because they were guilty of anything, not because anyone had decided they posed a threat, because the system produced their poverty as grounds for their detention, and the Don jail was where detention happened. This was the institution's population from 1864 forward. Not primarily the convicted. Primarily the not yet tried. Primarily the people the law called innocent. The cells held one man. They held two by 1880. They held three by 1900. The population for which the building had been designed had been exceeded before the century turned, and exceeded again before the Great War, and exceeded again and again and again across the decades that followed, each time producing a report that described the conditions as requiring attention, and each time receiving the attention of another report. The summers inside the Don were documented in medical testimony submitted to various provincial inquiries beginning in the 1880s as dangerous. The modified ventilation system produced conditions in the upper cell ranges that a physician described to the 1891 provincial inquiry as incompatible with the maintenance of reasonable health. The inquiry received this testimony. The 1891 inquiry's report recommended improvements to the ventilation system. The improvements were budgeted. The budget was revised downward. The ventilation system was not improved. The institution, in the language of every inquiry that examined it, was always requiring attention. The attention never arrived at the level of the problem. But numbers, even these numbers, can become abstract. Some of the people held inside the Don jail had names. Numbers, even horrifying numbers, can become abstract. So let us remember three of them. Arthur Morin was held in the Don jail in the autumn of 1972 on remand, waiting for a trial date on a charge that had not been proven, and that the law, in its formal pronouncements, presumed he had not committed. Before his arrest, Arthur Morin had worked as a laborer in Toronto's East End. He was 44 years old. He had a room in a boarding house on Parliament Street. He had a sister in Scarborough, whom he visited on Sundays. He was not a man whose life had been easy or whose circumstances were comfortable, but he was alive to the specific textures of his life in a way that the Don jail's intake records do not capture, and that his sister described, in an account given to a journalist in 1973, in terms that made him human in exactly the way that institutional records tend to refuse. He was not in good health when he entered the Don. He knew he was not in good health. He told the intake officer he had a heart condition. This was noted. It was not flagged for medical follow-up. He complained of chest pains on the first day, on the second day, on the third day. On each occasion, the complaint was logged in the duty register. The notation, on each occasion, was manipulative behavior. The notation was not a medical assessment. It was a classification. The guard's determination that the complaint was not genuine, that it was a tactic, that it did not require response. Arthur Morin died of a heart attack on the third day. He had not been tried. His charge had not been proven. The law called him innocent until the moment of his death, and for every moment before it. The coroner's inquest that followed his death produced findings that described the failure to provide medical attention as a contributing factor. The findings were entered into the provincial record. The guard whose duty register contained the 3 manipulative behavior notations was not charged with any offense. He was not disciplined. The duty register entry was not changed. There was no apology. Margaret Doyle was 23 years old in the spring of 1931 when she was held in the Don Jail's women's ward on remand, charged with a property offense the specific nature of which the surviving record does not fully preserve. She had grown up in the West End of Toronto. She had worked in a garment factory since she was 16. The women's ward of the Don Jail in 1931 was a section of the institution nominally separated from the men's ranges, but sharing the same infrastructure, the same inadequate ventilation, the same overcrowded cells, the same absence of programming or meaningful activity during the hours between lockdown and work assignment. Margaret Doyle spent 6 weeks in the women's ward before her case was resolved. The charge was withdrawn. She had been held for 6 weeks in the conditions the Don Jail provided on a charge that was ultimately not pursued. When she left, she was given the clothes she had arrived in. She told a neighbor, who told a journalist who included the account in a 1933 piece about conditions in the Don, that the 6 weeks had left her unable to sleep in a closed room for months afterward, that the smell of the air inside the ward had stayed with her in a way she could not account for, that she had gone in expecting the law to operate in a certain way, and had come out understanding that the law operated differently depending on who you were and what resources you had access to when the charge was laid. The province of Ontario did not acknowledge Margaret Doyle's 6 weeks in the Don Jail. The charge was withdrawn. As far as the institution was concerned, she had simply passed through. James Barton was 51 years old in the summer of 1958 when he arrived at the Don Jail on remand, charged with a summary offense. He was a veteran of the Second World War. He had served in Italy. He had come home in 1945 with injuries to his leg that had never been properly treated, and with what his family described as a personality that the war had permanently altered, prone to episodes of agitation, to difficulty in situations that reminded him of things he could not describe, and that the era had no proper name for yet. He had been in and out of the provincial system for years, not for serious offenses, for the category of minor infractions that the criminal justice system tends to generate around men whose poverty and mental health and visible difference from the norm make them continuously conspicuous to police. The Don Jail in 1958 had no protocol for the management of prisoners with mental health conditions. The infirmary was understaffed. The cells in the lower ranges, where men with behavioral difficulties were placed, were the worst in the institution. The ventilation least adequate, the supervision most minimal, the conditions most removed from anything that might plausibly have been called care. James Barton spent 11 days in the Don Jail before his case was heard. He was found not guilty. The record of his 11 days does not survive in any form that would allow a full accounting of what those days contained. His daughter, who was 7 years old when her father went into the Don, and 11 when he died, of causes his physician described as consistent with sustained institutional trauma, compounded by inadequate treatment, spent her adult life trying to find a document that acknowledged what had happened to him. She found his intake record. She found his discharge record. The 11 days between them are not in any file she was able to access. These 3 names represent hundreds more, the arithmetic of an institution that held, over 150 years, tens of thousands of people, the law called innocent, and the building processed as something considerably less than that. Many of those people left no record outside the intake register. Many are names attached only to dates of arrival and departure. Some were held for days and released when their cases were dropped. Some were held for months, while their cases moved through a court system whose pace bore no relationship to their ability to survive what the Don Jail was doing to them while they waited. Their suffering deserves to be named. The evidence of what the Don Jail was doing to the people inside it was not hidden. It was documented, repeatedly and specifically, in provincial records that are accessible in the archives of Ontario. In 1977, a coroner's inquest was convened following a series of deaths and serious medical incidents inside the Don jail. The inquest jury, a civilian body with the mandate to examine the circumstances of the deaths and make recommendations about the conditions that had produced them, took testimony for weeks. They heard from prisoners, from guards, from medical personnel, from provincial officials, from experts in correctional standards. The jury's verdict was specific. They found that the Don jail held unconvicted prisoners, people the law presumed innocent, in conditions that constituted cruel and unusual treatment. The cells were overcrowded by a factor that the jury described as incompatible with basic human dignity. The ventilation was inadequate. The temperature in the summer months was documented to exceed 100 degrees Fahrenheit in the upper ranges. The toilet facilities, buckets in some cases, were inconsistent with any standard the jury could identify as acceptable for human beings. The jury delivered 57 recommendations, not general recommendations, specific, numbered, actionable recommendations for the improvement of conditions in the Don jail. The provincial government received the recommendations. The Attorney General's office acknowledged them in the legislature. A response was tabled. The Don jail continued operating for 36 more years. Of the 57 recommendations, the ones that required structural investment, the ones that would have fundamentally altered the conditions the jury had described as cruel and unusual, were not implemented. The institution received the verdict of its own government's jury and absorbed it without changing. The government of Ontario that received the 1977 jury's verdict was never held accountable for the gap between the jury's findings and the government's response. No minister was investigated, no official was disciplined, no public process was opened to examine why 57 specific recommendations about the inhumane treatment of people the law called innocent had been received, acknowledged, and substantially ignored. The jury's report is in the archives of Ontario. The government's response is in the Hansard. The gap between them has never been the subject of a formal public accounting. The public understanding of what had happened inside the Don jail, such as it was, did not come from the government. It came from journalists, from lawyers who represented prisoners, from academics, and from the prisoners themselves, whose accounts circulated in the specific informal channels available to people. The formal system had given no official voice. By the 1960s and 1970s, a network of legal aid lawyers working in Toronto was accumulating client testimony about conditions in the Don that was consistent across clients who had no reason to coordinate their accounts. The testimony described overcrowding so severe that prisoners slept in shifts. It described the summer heat as producing a smell that did not leave you. It described the arbitrary application of institutional discipline, the denial of medical attention, the specific psychological effect of being held, presumed innocent, in conditions that communicated something quite different about what the institution thought you were. In 1977, the CBC's investigative journalism unit produced a documentary about conditions in the Don jail that aired on national television. It included testimony from former prisoners and from a prisoner rights advocate who described the institution in terms that the 1977 inquest jury would, within months, confirm in official findings. The documentary was watched by a significant audience. The government acknowledged it. The inquest was, in part, a response to the pressure the documentary generated. The recommendations were issued. The recommendations were received. The recommendations were not implemented. A 1985 provincial report on conditions in Ontario remand facilities described the Don jail as the most problematic remand facility in the province. It recommended urgent action. Urgent action was not taken. A 1994 provincial report described conditions in the Don as having not materially improved since 1985. It recommended urgent action. Urgent action was not taken. The Don jail operated until 2013. In 2013, the province of Ontario closed the Don jail's operational cells as part of a consolidation of Toronto area correctional facilities into the newer Toronto South Detention Center. The closure was described in provincial communications as an operational and financial decision. The word inhumane did not appear in the communications. The phrase cruel and unusual treatment, which had appeared in the 1977 coroner's inquest, jury's official findings, did not appear in the communications. No apology was issued. No compensation program was established. No public acknowledgement was made that the conditions the government's own jury had described in 1977 as cruel and unusual had been permitted to continue for 36 years, while tens of thousands of unconvicted people passed through the institution the jury had described. The Don Jail was not an anomaly in the Canadian correctional system. It was a representative expression of what that system, applied to the poor, the mentally ill, the addicted, and the unconvicted, tended to produce when the accountability structures were insufficient to the scale of the harm. The Metro Toronto East Detention Center, which operated alongside the Don Jail for parts of the latter's operational life, was described in provincial inspections during the 1980s and 1990s in terms nearly identical to those used for the Don. Same overcrowding, same inadequate ventilation, same absence of programming for remand prisoners, same gap between the conditions and any standard that the inspectors themselves could defend. The Elgin Middlesex Detention Centre in London, Ontario, was the subject of a provincial coroner's inquest in 2014 following a series of deaths in custody. The inquest produced recommendations. Many were not implemented. In 2020, 6 more people died in the facility in a single year. A second inquest was called. The pattern, the death, the inquest, the recommendations, the non-implementation, the next death, is not a series of failures. It is a system operating as designed. The design is the failure. The people held in these facilities are predominantly remand prisoners, predominantly poor, predominantly with mental health conditions or addiction issues, or both, predominantly without the resources that make navigating the bail system possible, predominantly from communities that have less access to the political processes that generate accountability for institutions that harm them. The system processes them as though their poverty were a public safety problem. It holds them in conditions that a government's own jury once described as cruel and unusual. It issues reports. It ignores the reports. It issues more reports. In 2020, the province of Ontario was still holding remand prisoners in conditions that provincial inspectors described as inadequate. The Don Jail had been closed for 7 years. The conditions had moved to newer buildings. The buildings were newer. The conditions were the same. The Don Jail stands, today, at 550 Gerrard Street East in Toronto. It is no longer a jail. In 2014, the building was converted into administrative offices for Bridgepoint Active Healthcare, now Sinai Health, which operates a major hospital campus on the same site. The conversion was designed by the architectural firm KPMB, which won awards for the adaptive reuse. The conversion is genuinely beautiful. The dome has been restored. The sandstone exterior has been cleaned. The arched windows admit light into office spaces, where hospital administrators work at desks in cells that once held 3 men in the space designed for 1. The building today is a workplace, quiet, ordered, warm in winter, air-conditioned in summer. The air is clean. The original 1864 building still stands as the front portion of the complex, its facade intact, its dome visible from Gerrard Street. The newer additions, the wings added in the 1950s that house the bulk of the cell population through the institution's final decades, have been incorporated into the broader hospital campus in ways that make the complex's history legible if you know what you're looking at, and illegible if you don't. There is a small historical display in the converted building's lobby. It describes the Don Jail's history in general terms. It notes the 1864 opening. It notes the 34 executions carried out within the walls between 1872 and 1962. It notes the closure in 2013. The display does not name Arthur Morin. It does not mention the 1977 coroner's inquest jury or its 57 recommendations. It does not mention the phrase cruel and unusual treatment that appeared in the jury's official findings. It does not note that the conditions described in those findings were permitted to continue for 36 years after the finding was made. There is no plaque on the exterior of the building naming the 34 people executed within its walls. There is no memorial in the converted offices acknowledging the tens of thousands of remand prisoners, unconvicted, innocent in the law's own language, who passed through those cells. The dome is beautiful, the air is clean, and the people the building held are not mentioned in the building that held them. There are 2 Don jails. The first is the building William Thomas designed in 1859, the building of the dome and the Romanesque arches and the ventilation shafts and the careful proportion. Thomas believed he was designing an instrument of progressive reform. He believed that a well-designed building could reach into the problem of crime and produce something better than the dungeon and the gallows had produced. He was a man of his era's optimism, and that optimism was genuine. The Don Jail, as he conceived it, was a statement that Toronto had arrived at a moment of civic maturity, that it could respond to its social problems with deliberateness and humanity. The second Don Jail is the building that operated for 150 years inside Thomas's shell. The building wherein an unconvicted man died of a heart attack after his complaints were logged as manipulative behavior, where a coroner's jury used the phrase cruel and unusual treatment, and the government received the phrase, filed it, and continued the budget, where the cells built for one held 3, where the summer air in the upper ranges was documented to exceed 100 degrees Fahrenheit, where the people being held were, in the law's own formal language, innocent, and were treated as though the law's formal language and the institution's daily practice were 2 entirely separate things that never needed to be reconciled. The worst the first Don Jail did was make a promise it could not fully keep. The worst the second did was receive, in writing, the evidence that it was breaking innocent people, and keep operating for 36 more years without changing the things that were doing the breaking. Both institutions had the same dome. Both processed the same people. Both were called justice. The unanswered questions remain. How many people held in the Don Jail as remand prisoners, unconvicted, innocent in law, experienced the conditions the 1977 coroner's jury described as cruel and unusual? The number across 150 years is in the tens of thousands. It has never been the subject of a formal accounting. Of the 57 recommendations made by the 1977 inquest jury, which were implemented and which were not, the government's response is in the Hansard. A comparison against the 1994 provincial report finding that conditions had not materially improved since 1985 would answer the question. That comparison has not been published by any provincial body. What would a formal public acknowledgement of the gap between the 1977 jury's findings and the government's response look like, delivered not by a researcher or a journalist, but by the province of Ontario in its own voice? To the people and the families of the people who were inside the Don during those 36 years, that acknowledgement has not been made. The dome is still there, cleaned, restored, catching the afternoon light off Gerrard Street in exactly the way William Thomas designed it to. The offices inside are warm and quiet. Hospital administrators work at their desks in rooms that have been entirely reconceived. The air is circulated by a system that functions exactly as the original was supposed to. The people who breathe the air that the original system could not circulate are not here. They are in the record if you go looking. Intake registers, inquest transcripts, duty logs with entries that read manipulative behavior in the handwriting of someone who has never been asked to account for what that entry meant. The dome was always the promise. The duty register was always the truth. Arthur Morin died on the 3rd day. The law called him innocent. What did the Don Jail call him?